for possession of heroin on August the 20th of 2020. Now, there was a notification filed by the probation department, Ms. Hensley, today that alleges that you failed to comply with those conditions set forth in your big control entry, specifically Rule 2 that you haven't reported since February 23rd of this year. Rule 15, you failed to pay the court-imposed financial sanctions, court costs. And Rule 19A, that you have failed to comply with the substance abuse treatment for Brighton. Now, you are entitled to have a hearing on this matter if you can't afford, and if you are entitled to have an attorney, if you cannot afford to hire an attorney. Court will appoint one for you, and I see you have filled out a financial disclosure form. Is everything on this correct?
Yeah.
When's the last time you were employed?
It's been about a year ago.
All right. Well, the court then will find that you are entitled to appoint counsel, appoint Mr. Kirk to represent you in this matter. Set the matter for hearing July 20 at 1 p.m. You'll be held without bond. We'll notify him of his appointment. You can also, anyone try to get in touch with him if he doesn't get out to see you in the next day or so. You have any questions?
Your Honor, you pledged you set the date.
July 20 at 1 p.m.
Thank you.
All right. Do you have any questions, Ms. Hensley?
No.
All right. Thank you.
Thanks.
Let's see. Mr. Armstrong representing both of these.
Yes, sir.
bonds and a fine of $10,000. And your entitled counsel and Mr. Kirk, I've already determined you are indigent in your other case, so that may be defined here, and I'll appoint Mr. Kirk to represent you. In his absence, enter a not guilty plea. We will set your first pre-trial in this matter for, let's see, what is today? Today is July the 13th, so we'll set this for August 11th at 1 p.m. On the pre-trial will be August 25th at 1 p.m. And your trial date will be September 23rd at 8 a.m. Bond will be set in the amount of $10,000 plus your oath of promises, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony and sentence, convicted sentence on that charge in this case. If you do make bond on this charge, then you will be under pre-trial supervision at the probation department, 117 East Main Street, under court there immediately upon release, and then once a week for 4 weeks, and after that, as they determine, undergo a drug test in order, provide phone number for home son employer, no contact the alleged victim, if recommended by probation, be evaluated for substance abuse and mental health issues, and any treatments indicated, you enroll in and follow that during offense of this action. And you also be in a house arrest at your residence, meaning you have to be at all times that you're working from work. Medical appointments, court proceedings, appointments in this or any other case with an attorney. Otherwise, you have to be there all the time. If you fail to comply, then you could have your bond revoked and be held in custody until further court. Not going to set a bond review in your case that is academic because you're being held without bond on your probation violation, at least on that Thursday, and then we can review it at that time. All right, have any questions?
No, thank you, Your Honor.
All right, thank you. All right, let's do Mr. White. Okay, we have two cases here, 21 CR 108, 21 CR 071, both State versus Tennessee White, J. White, here on behalf of the state. Both cases, Assistant Prosecutor King, here on behalf of defendants, American Harmon trial. You are Timothy J. White.
Yes, sir.
All right, Mr. White's counsel has requested evaluation of the defendant's mental status. The court ordered that evaluation as well as evaluation as to mental state at the time of the alleged offenses. The court did see the report from the Forensic Evaluation Center. The report has been provided by the examining psychologist Carla C.C.A.R.L.A.S. Dreer, D.R.E.Y.E.R. and Stephen Dreer, Dreer. Date evaluation was 7/2/21 and the date report 7/9/20. Each of the attorneys received copies of the evaluations.
State has answered.
Right, is there any further information presented from state?
Your Honor.
Sure, I'm trying.
We'll submit on the report, Your Honor.
And the court will find that the defendant is not going to stand trial in both cases. That's the finding of Dr. Dreer. And we'll put the case back on the active docket. The court will set the final pre-trial in this matter for August 11th. Set the trial for August 26th. August 11th will be at 1 p.m. August 26th, trial date will be at 8 a.m. Speed trial time will be extended hold for 29, 45, 72 C and H. All right, anything further in counsel?
No, sir. That's all.
All right, thank you. All right, Ronald Hausman. Alright, we have, case number 20 CR 85, State of Ohio, versus Ronald D. Housman II. Here on behalf of the state is Assistant Prosecuting Attorney King. Here on behalf of the defendant, State's Attorney Marmtrout. Are you Ronald D. Housman II?
Yes, sir.
All right, Mr. Housman was convicted of aggravated possession of methamphetamine, a fifth-degree felony, placed under control on October the 8th of last year. He was issued for arrest in March, and he was taken into custody and notified of his alleged violations on June 9th, and followed Officer Bolser, who's also present. And then the court appointed Mr. Marmtrout to represent him. Actually, notification on the 30th, I guess it is. Yeah, on the 30th. And then there was everything. All right. Now, Mr. Marmtrout, get out there and review these allegations with your client.
I have, Your Honor, but Your Honor, only briefly, as the court's aware, I was out all last week, did not have a chance to speak to Mr. Housman until just now. I've gone over the violations with him. I'm not a doctor, I don't know whether he understands the nature of this proceeding or not, as the court can see, he's having some movement issues right now. He was able to give me some explanations, so I guess at this moment in time, and the court's aware it's not an alleged violation, there is a new indictment for a serious charge against him, so if the state wants to go ahead and proceed today, we're ready to go forward.
Okay, well, are you going to file a competency on the other case?
Yeah, absolutely.
Well, then I think what I'll do is I'll just continue this matter then until that time. You know, the issue of competence to stand trial traditionally applies to trial, but I think it's also applicable to post-conviction proceedings when there's a potential for incarceration. And so, matter will continue. And, so if you get, competent motion filed in the other case, then we'll, go from there. All right, anything else? Thank you.
I'll see you. That's all right.